Testen, testen. Okay, welcome to the Public Service Commission's administrative meeting for April 23rd, 2025. Before we get to the business at hand, we have two new folks joining us. First, Sam Byrne is joining the Energy Analysis and Planning Division as an assistant director to focus on offshore wind. Mr. Byrne comes to us as a graduate of Syracuse University and had been working with the Maryland Energy Administration. So, Mr. Byrne, we welcome you here and look forward to your work. And we have, as you notice, we have a new member of the bench. And it's a new member, but sort of an old member. We want to welcome back Commissioner Obi Linton. Commissioner Linton served the Public Service Commission for a number of years and then went off briefly, but has been recently appointed to fill out the term of Commissioner O'Donnell. So we welcome Commissioner Linton back to the panel. And do you want to make any comments? Or?
Well, thank you, Mr. Chairman, and to my new colleagues, and for Commissioner Richard, my older colleague. Good morning, everybody. I appreciate the opportunity, the time to be here today, and look forward to continuing to serve the citizens of Maryland. So I won't take up any time.
Okay.
Thank you very much.
Thank you very much. So the first thing we need to do is approve the minutes from our administrative meeting of April 16th, 2025. Commissioner Linton.
I will abstain, I guess. But
yeah, you go. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Morning, Mr. Chair. There's two items on today's consent agenda. Item number one is a request from Agway Energy Services LLC to cancel its electricity and gas supplier licenses. And item number two is a request from New Market Solar LLC to extend its construction and operational deadlines.
Okay, regarding item one, I move we approve the cancellation request. Commissioner Linton.
Aye.
Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Apologize, Commissioners. OPC actually opposes the recommendation from staff and would like to have a discussion on the item, if
Okay.
possible.
Yeah, let me hear it real quick. So.
Okay. Apologies about that. OPC, good morning. Milan Tekla-Mikhail on behalf of the Maryland Office of People's Counsel. OPC in this matter disagrees with staff's recommendation to approve Agway's request to relinquish its license and electric and gas supplier licenses. OPC instead recommends the Commission require Agway to keep its licenses active and maintain all of its bonds for a period for at least the next 3 years to cover liabilities to its former customers. Agway has been a licensed electric and gas supplier permitted to provide services in Maryland since September of 2017. According to Agway, it no longer has any customers, but it has provided services to residential customers within the past 3 years. In recent matters before the Commission regarding retail supplier requests for license relinquishment, as well as transfer of contracts, the Commission has denied Great American Power LLC and Tomorrow Energy Corporation separate requests to relinquish or transfer their customers. In both matters, the Commission cited the potential for future complaints by former customers and the need to have jurisdiction over the companies to hold them accountable for such complaints to support its decision. The Commission reasoned that allowing the companies to relinquish their license while they may be responsible for future complaints by former customers would not be in the public interest. In the Tomorrow Energy matter, the Commission ordered the company to maintain its license for a period of 3 years. OPC asked the Commission to apply the same reasoning in this matter and order the same measures. As it is in the public interest for the Commission to require Agway, a supplier within the Commission's current jurisdiction, to demonstrate it has met all of its outstanding obligations to its former Maryland residential customers before it is allowed to relinquish its license and leave the state's regulatory reach. The Commission, similar to its previous order, should thus require Agway to maintain its licenses and bonds in Maryland for at least 3 years to protect the interests of Maryland residential customers. Former customers could still bring timely complaints against the company, and thus the Commission could access the bonds to render any obligation the company might have to its former customers. So that is all we have on the matter, and thank you for your attention.
So let me ask staff, I mean, I noticed on the sheet that was filed that they don't have any customers. Did they ever have any customers?
They did, and actually, if you look at the, good morning, Chair and Commissioners, Charles Herbert on behalf of staff. You look at the EIA 861 data for 2024 and 2023, they still had some residential customers at the time, less than 10, seeing the BGE service territory. But yes, as of now, they have dropped all customers. They actually do not have any load in PJM GATS, so as of now, they are done as far as their operations and with customers.
And I also noticed that there's no complaints, right?
No open complaints. So in the company's history, as a licensed supplier in the state, they had 2 complaints that were filed against them. One was filed and closed in 2019, and the other was closed in 2020. And after that point, they had no complaints. Minimal compared to other suppliers.
Yeah,
that
no, I
perhaps
understand. And so I guess the concern that we've had with these companies in the past is making sure they don't leave town and leave us holding the bag, so to speak. But I guess that doesn't really apply in this case, right?
It's staff can't see any reason that there would be future obligations that would come up as far as complaints are concerned. And additionally, staff wanted to note that in some of the other recent cases we've seen, the license cancellation request was preceded by a notice that the supplier was assigning customers to a different supplier. In this case, we actually have that the customers were dropped to SOS. So the concern where, maybe
Right.
customers are being transferred to a supplier with a worse complaint history
Yep.
doesn't really apply here because you're dealing with the utility as the new provider.
Okay. Any questions for staff or OPC?
Yeah, Mr. Herbert, are there, so the supplier had 10 customers? Is that what you're saying?
Fewer than 10 for each of their licenses.
Okay, so fewer than 10 for gas, fewer than 10 for electric. Is that what you're?
Yes.
Okay, and I think what OPC is concerned about is even if you have a single customer that has an issue or has reason to file a complaint, if the bond is not present, there's no recourse. And so I guess what I'm asking is whether you can envision a situation where there could be a reason why a customer, even on an SOS, would discover that there was a problem in the preceding 3 years, 2 years, and would want to file a complaint, but would have no recourse because we've canceled the license and the bond.
Commissioner, I'm not going to say that it's impossible. However, the fact remains that the last complaint against this company, which was only the second complaint, was closed in 2020, and staff is always maintaining communications with consumer affairs, and besides giving us
Right, but I think the problem is, where do we draw the line? So, it just seems to me, I mean, we're hearing these cases before us, and I think that if we can have a bright line where we just say, you've announced that you want to drop the license. We're going to allow you to do this, but we're going to sort of suspend it for some period of time and require that the bond be in place. It would make it so much easier for us to then render a decision rather than sort of balance it every time the situation comes up. And my guess is that it's going to continue to come up. And to the extent that we can craft something that that represents a bright line, so that we're not sort of trying to guess, well, what are the odds of a customer bringing a complaint? Because as a lawyer, I mean, the odds are, from our perspective, the odds are always very high, because that's the only time we ever see clients. I mean, we're lawyers, see clients is when they have a problem, and I just want to, I just want to avoid a situation where we could end up with a problem.
Commissioner, if I may, pipe in. I think OPC, that is also our angle, and our recommendation is in line with that. We are trying to create this 3-year bright line sort of situation where within 3 years they have the ability to, customers typically have the ability to bring in complaints. So if a company has not provided services to residential customers within the past 3 years, it shouldn't be a problem. But if they have provided services within the past 3 years, there's still the potential. It cannot be argued that there's a null and void chance that, a customer cannot bring in a complaint if they have provided.
Yeah, I mean, that's my concern, is that we don't know. But the other thing is, I'm sort of troubled by having to constantly be balancing, what are the chances here, as opposed to just sort of creating some kind of bright line where this is what happens when you want to relinquish a license. You have to, it has to remain in place for 3 years. The bond has to remain in place for 3 years, and after 3 years, you're no longer licensed, and you get the bond back.
And that also promotes administrative efficiency.
Well, that's what I'm thinking too. Is that we'll have less of these, because it's just going to be it's going to be a ministerial process, as opposed to sort of a balancing act that I think is really hard for us to do. And I'm assuming from staff's perspective, if you have some kind of process in place, it's going to be much easier to just sort of do these, because that's and the licensee is going to know this is what our process is.
Oh, well, Commissioner, I will note that when an entity continues to be licensed, we still have to make sure for an ongoing basis that they're maintaining compliance with the administrative requirements of that license. Assessments would still be generated, and we would still have to monitor things like that. So may increase administrative efficiency in some areas, but then there are other areas where they cancel that out. I would like to point out that this company has not had any customers in over a year at this point. So.
Well, then, maybe you can come up with. I mean, this is all because of SB1. So we're sort of in new territory. Maybe you can devise some kind of sort of quasi licensed category where they don't have to meet certain conditions. I'm just sort of troubled that we're doing a number of these things, and I just feel like it's really impossible for us to predict the future.
Commissioner, I do think that it's probably not a bad idea to develop, a firm line. I think that would be helpful. It'd be nice not to have to argue over this each time and one of these comes up, and it would be easier both on staff's decision making and the commission's decision making. So I think I agree with that, but I also think that's not something we can do ad hoc now at an admin. It's something that would require internal discussions, maybe discussions with the commission directly and or with OPC as well, and maybe other interested stakeholders. So it's not just one thing. The other thing I would remind you that the bond, such as it is, it's not something that can be automatically accessed. The commission has to either make a finding that the company is insolvent and unable to meet its obligations, or the customer in question has to go through a court and get a judgment in court before they can draw on the bond. Come to the commission and draw on the bond.
Right, but at least we know the bond is there.
Yeah.
So there is recourse at some point.
At some point.
Yeah. Okay.
Senator Barbe.
Thank you, Mr. Chairman. Why 3 years?
The 3 years is the statute of limitation for a customer to bring in a complaint for infractions that have previously occurred. So it gives them a 3-year period for to bring a complaint before the commission or even to any other Maryland court.
Well, I don't know where to draw the line, but I don't think this is the place. Thank you.
Anybody else? Commissioner Linton?
Just one question. Is the company represented here today?
The company informed staff that they could not make it today.
Okay. Were they aware of the People's Council's concerns?
Yes, we did serve the company's counsel with our comments.
Okay. And you'll forgive me since it's my first day here, but did they respond or did they file anything in response to the People's Council?
Their staff couldn't find any subsequent filings from the company. We checked this morning, and there was no response from the company to OPC's letter.
Just one other question. And how long is the current bond still good for? I know they don't last forever, so the company itself will have to do something to renew them.
Yeah, I don't have. I would have to check the bond itself, Commissioner. I don't have it in front of me right now, but I could get back to you on that when the next renewal is. We haven't gotten any sort of cancellation notice for it, so.
Kevin Mosher on behalf of staff. Commissioner Linton, this is probably like virtually every other bond where the company would have to give the commission, I believe, 60 days notice prior to canceling the bond. So we haven't received that yet, so it should at least be good for an additional 60 days.
Thank you. Thank you, Mr. Chairman.
Okay, so do we want to approve the cancellation, defer it?
Yeah, I mean, the concern I have is I mean, I'm less concerned about this situation, but I'm more concerned about how do we balance with each proceeding. Can we defer this?
All right, so let me do this. Let me move that we reconsider the motion that I made to approve the cancellation. So all those in favor, Commissioner Linton?
Reconsider to extend to future time? Or?
Well, I want to reconsider the motion I made to approve the cancellation.
Okay. Aye.
Commissioner
Aye.
Commissioner Barbe?
No.
Commissioner Richard?
Aye.
I vote aye. So with that, why don't we defer this to a future meeting, and in the interim time period, why didn't staff put together a proposed policy on these cancellation issues related to existing customers or no customers, and we'll consider that at a future meeting. So.
Okay, will do.
Okay. All right. So regarding item 2, I move we grant the company's request to and extend the deadlines imposed by the commission such that the company's project must commence construction by October 27, 2026, and must begin operation by October 27, 2027. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
I vote. Commissioner Richard.
Aye.
I vote aye.
Item number 3 on the administrative agenda regards the cancellation of operating authority for RCLEC Inc.
Good morning, Mr. Chair and Commissioners. Cameron Walton on behalf of staff. On February 7th, 2025, ArcLec Inc. filed its request to voluntarily surrender operating authority as provider of facilities-based local exchange and interexchange services in Maryland, as well as a request to cancel its associated tariff, PSC MD Tariff Number 1. ArcLec has not served any customers pursuant to the authority for the past 2 years. The company is SDAT compliant and has no outstanding fees with the Commission. Staff finds that ArcLec has satisfied the requirements relating to the discontinuance of local telephone service set forth in Comar 2045-0413. Therefore, staff recommends the Commission cancel ArcLec's authority to provide facilities-based local exchange and interexchange services in Maryland, as well as its associated tariff, PSC MD Tariff Number 1. Thank you, and I'm available for any questions.
Any questions of staff? Seeing none, I take it there's nobody here from RCA, right? Okay, I move we cancel the company's authority to provide facilities-based local exchange and inter-exchange services in Maryland, as well as its associated tariff, PSC Maryland Tariff Number 1, with the understanding that the company will file a new application for operating authority if it seeks in the future to offer any services in Maryland over which the commission has jurisdiction. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 4 consists of tariff revisions from Baltimore Gas and Electric Company.
Good morning, Mr. Chair and Commissioners. Eric Delgado on behalf of staff. On March 14th, 2025, the Baltimore Gas and Electric Company, BGE, filed proposed tariff revisions to its Rider 1 standard offer service rates for residential and Type 1 customers that go into effect June 1st, 2025 through September 30th, 2025. BGE proposes adjusting the SOS rates to reflect actual capacity costs from PJM's third incremental auction results. BGE states that the updated SOS rates would enable the company to promptly and transparently reflect the actual capacity costs, given that actual capacity costs are significantly higher than the capacity proxy price used to determine the current published SOS rates set to take effect on June 1st, 2025. PJM's third incremental auction report for 2025-2026 delivery year indicates that BGE had a significantly higher clearing price, which reflected continued constraints on supply and demand conditions in the eastern part of the PJM region. The final zonal net load price for BGE was $306.84 per megawatt day, which is significantly higher than the proxy price used to calculate the current June 1st SOS rates. Since PJM's capacity price is a pure pass-through cost invoiced by PJM, any differences the capacity proxy price and the actual capacity costs are recovered through BGE's Rider 8 energy cost adjustment, which is a true-up mechanism that compares retail customer billings for energy and transmission services against payments made by the company to wholesale suppliers and PJM. However, since actual capacity costs are significantly higher than the capacity proxy price, residential and Type 1 customers would incur a significant increase in rates via the energy cost adjustment. Considering the options available, staff believes it is in the best interest of BGE's customers to be informed of the impending SOS rate increases now through the tariff, rather than waiting for a substantial increase in rates through BGE's energy cost adjustment. Additionally, staff notes that if costs are left to be recovered through the energy cost adjustment, that customers would incur higher rates since the energy cost adjustment would take effect in October, which provides customers 8 months as opposed to 12 to recover the difference in capacity costs. A residential customer using 1,000 kilowatt hours can expect a bill increase of $15.84 per month. Staff recommends the Commission accept for filing BGE's proposed tariff changes with an effective date of June 1st, 2025. Thank you, and I'm available for any questions.
Any questions for staff? Commissioner Richard.
Yeah, thank you for your presentation. Can you just, trying to understand just the mechanisms at this point of how these new charges are made. I think the way it was termed in your buck sheet, there's an invoice that'll be sent to BGE. Is that how the difference in price? Because I'm just trying to understand between the fact that we have already procured this through an auction for the SOS. Now the prices have gone up because of the auction. How are we proposing to reconcile this?
So the first three procurements that BGE have made for these rates that are set to go into effect June 1st, they utilize a capacity proxy price.
They used a proxy, right? So that was factored in, and that was what was offered.
Yeah.
And that's what we purchased, essentially. Or I should say the utility is purchased for standard offer service.
And so that is being trued up with the actual capacity price from the recent auction,
Okay.
and the difference is being added on to the rates.
So and then with the new process, and I see Lloyd may be able to explain this to me. We now have just an absolute a pass through. So the risk really is being fully borne by the ratepayer, and not the fact that the auction took place and there was a proxy that was included, but still.
Well,
This risk now is not being borne by the those that bid for SOS, but is being borne by the ratepayer.
That is correct, and that's, I mean, you have to bear in mind that by shifting that risk, they allow, it takes risks off the bidders, and that maybe allows them to have a lower bid than they otherwise would have. Certainly, not having responsibility for guessing what the capacity price will be, and hoping they were on the mark.
Right. Well, fair, but
it's
but it is suddenly a rate shock. I mean, that's happened because of what's occurred. And I guess this is, obviously we can't do a lot about this today, but it really, I find difficult that we are about to impose an unjust and unreasonable rate, and that's really even admitted by PJM. They had a flawed auction design through the RPM. We know that they're fixing it for the next auction, but the RMR that we have, the reliability must run, was not considered. The must offer was not considered. All these things that PJM admits is a flaw, and created an unjust and unreasonable new rate is now going to be borne by our ratepayers, and we're going to do this in kind of a rate shock manner. Essentially, what's happening, right?
Well, and there's certainly it's going to increase rates, and at least by some noticeable amount. So there is a degree of rate shock involved, I guess. I would note that the thing is, we're kind of stuck with conditions as they exist at the time when the bids occur, and with the conditions that we establish as well. So it's
Yeah, I think stuck is a good word, yeah, because this isn't the first time. It seems like the previous auction for the DPL South, another error took place by our RTO, and that imposed a large cost that they can admit now was unjust and unreasonable, but still somehow none of these errors are ever borne by those making the mistakes. They're always borne by the ratepayers of our state.
Ultimately, I mean, the people who, if you were going to say that the people making the mistake was somehow PJM in the terms of the structure of the bidding, for example, ultimately it would be up to FERC to determine whether or not there was some form of penalty that needed to be imposed on PJM. That's their jurisdiction.
Okay, yeah, and I would just note that some of the consumer advocates are have a case that they're taking to FERC saying, okay, we've taken care of the mistake, at least we're starting to take care of the mistake for the future auctions, but what about the auction that now we know was flawed, and yet we're still going to impose a huge new cost on ratepayers? So that's before FERC right now. Is that correct?
That's my understanding, and I mean, the consumer advocates can't have that ability to file that complaint to FERC. The commission, if it chose to, could as well, or the various states. There are parties with standing that have standing before FERC to file that kind of complaint, and seek some form of redress. I cannot say I have any real knowledge of what the type and form of redress FERC could allow, but whatever there is can be sought.
Okay, thank you. Well, I'm go on more with this, but yeah, thank you for engaging me on that colloquy. So thank you, and I look forward to hearing shortly from BGE as a member, both as an EDC and a transmission owner to PGM, what they're doing as far as governance to try to figure out how we make sure these mistakes are not made in the future, and is there any possibility to try to shift some of the mistake back to those that made the mistake in the first place. So this unjust and unreasonable new cost on our ratepayers is more justly borne by the system. Thank you, Mr.
So
Chair.
actually, hold your response. Let me have Commissioner Barbe, a question for staff. So.
Yep, thank you, Mr. Chairman. For the sake of the record, describe to me what the train of events would be if we do not accept these tariff changes. How would they play out? Because I've read this, but I'm a little uncertain as to what the chain of events would be and how they would affect our consumers.
Well, I would say that, the way the full service requirements agreements are configured, I mean, this is something that gets to be passed through, and that's or what the commission has done previously.
Mm-hmm.
So, ultimately, it would be very difficult for the commission to turn around and say, well, we said this was going to be a pass-through, but it's not going to be. I think you would find yourself in legal jeopardy at that point. So, I don't know that that would be an option that you would realistically want to consider.
But let's say we did. Let's say we just refused to accept these tariff changes right now. What would be the consequences of that?
Yeah, I mean, if you didn't accept these, they would probably try and have them go through a revision to rider aid come October, when PG is normally entitled to do that. And you would be presented with the question again at that point.
I mean, is there any possibility between now and October that the provisional rates would be trued up in any way so that we'd have a more firm, proper, actual type number? Or would the effect of not approving this now be to simply increase even more what the effect would be on ratepayers in October?
Ultimately, yes, because by doing this now, BG is actually seeking to try and ease the burden on ratepayers a little bit, because it spreads the increase over the course of a year. Whereas if you waited until doing it in October and having it start then, you would have to spread the same pot of money and the same increase over 8 months. So it increases the amount of the actual rate that you would have to do to implement it.
So it's a pay me now or pay me later type situation.
That's what it amounts to, Commissioner.
Well, I have to say I have a lot of sympathy for the frustration that Commissioner Richard has shown, but I mean, it's bracing to realize what the mathematical realities of this of the box that this puts us in. So thank you for your answers. Thank you, Mr. Chairman.
Commissioner Sussman.
So I'm wondering if it's not just a pay me now or pay me later. I'm wondering if it's a pay me at all. So as Commissioner Richard pointed out, and he is much more steeped in the PJM matters than I am, there are complaints that are before FERC about the auction that was run, and there is a possibility that FERC will find in favor of those parties, and at that point, what happens if we approve this? Do ratepayers get redress at that point?
It's really hard to say. I mean, because you're really talking about a situation that's, as far as I know, a matter of first impression. So it's not something, where we have a course that would definitely be laid out.
So I understand. I mean, I understand I know about the filed rate doctrine, and I know about having to put these rates in effect. But if we believe that the auction was improperly run, and if we agree with the positions that have been taken before FERC, why would we implement a rider when we doubt the efficacy of the of the auction that was run. Why would we do that?
I mean, I think I mean, it's hard to say for sure, but I think you're looking at a likelihood of FERC unwinding things being very low, honestly.
Well, but on some level, it doesn't really matter what the I mean, if FERC will make its decision, but if we have a problem with the auction, and if we're in agreement with the challenges to that auction, you're telling us that we have to accept the results of the auction pending consideration by another body of whether it was properly run or not?
I don't know that you have to, Commissioner. I don't think I would go that far, but I would say, unless FERC does give whatever the redress they're seeking is, there's a strong possibility you end up putting ratepayers in a worse position when all is said and done, because you will have delayed the payment that otherwise would be due, and that might.
Yeah. So, Mr. Spivak, I understand what you're saying. I just, I get a little tired of being told that my hands are tied because FERC makes the decision. That we're responsible. FERC is not responsible to the ratepayers of Maryland. We're responsible to the ratepayers of Maryland. I don't understand why, if we have a problem with the auction, that we just have to, as Commissioner Richards said, we just have to shut up and do what they tell us to do. I have a real problem with constantly being told, I'm sorry, but FERC is in charge, and this is. We're ultimately responsible, and we're ultimately in charge of taking care of ratepayers, and I don't think we're doing them any service if we accept the result of an auction, and that will result in huge rate increases, and for some customers, the inability to pay those rates. I don't see the point of doing that when we have a fundamental. It's one thing if we didn't have a problem with the auction, but we have a fundamental problem with the auction. Why are we accepting the results of that auction, resulting in substantial rate increases for customers that are already being overbilled?
You have the option of not doing so, Commissioner, but there are potential consequences.
Yeah,
I
Mr. Chairman,
I
I would oppose the rider as proposed right now.
Commissioner Linton, any questions? Okay. Commissioner Barbe, go ahead.
Thanks for a second bite at the apple. So let me ask the question in this manner. Let's suppose that we refused to accept this right now, and let's also suppose that in the alternate universe, FERC actually ruled in our favor and decided to sanction in some way PJM for having run a fundamentally flawed. Excuse me, I asked the question the wrong way. Let's say we accept these tariffs right now as they are, and then FERC rules against PJM decisively. What recourse do we have in a future date to recompense our ratepayers? Do we have any at all?
There is Rider 8. I think that would be one option to put it through, because that is the true-up mechanism for this exact issue.
I think Mr. McAuliffe has it right. I mean, to the extent that FERC makes a ruling that would do that, I mean, then there would be money that would go back to BGE, because BGE is the one that made the payment, and BGE in turn would be obligated to flow that money through to its ratepayers, because this is a pass-through. So,
so the money wouldn't be lost to the ratepayers ultimately if FERC ruled in our favor.
Ultimately, if the money had to go back to BGE, it would then flow back to ratepayers. That's correct.
Okay, thank you very much, Mr. Chairman.
So, go ahead.
Good morning, commissioners. Welcome back, Commissioner Litton. Long time no see. glad to see someone who's been around longer than I have now. I was starting to feel old. Appreciate staff's thorough analysis. As usual, their questions, often help me out to understand things. But I do want to level set a little bit here. The premise of this filing is not changing, or that the fundamental purpose of this filing is not to shift the risk. That actually happened 5 years ago when the Procurement Improvement Process Group came to the commission because of the delays in the FERC or on the PJ auctions and said, hey, we've got these delayed auctions. We're going to start using a proxy price the suppliers will use a proxy price, and then when the actual price is known, it will just get trued up through Rider 8. That's been going on for 5 years now. What happens with this filing is, again, normally this would get trued up through Rider 8. And as staff indicated, that would be over an 8-month period starting in October. We're saying, hey, instead of recovering this over 8 months in October, let's start recovering it now through the Rider 1 rate instead. So that's the only change being made in this filing, is the mechanism for truing up the actual capacity costs to the proxy capacity costs that were included in supplier bids. Again, 5 years we've been doing this. This is not the only auction where, certainly the magnitude has changed here, but, this has been the same mechanism that has been used, again, for the last 5 years, that, because we didn't have an auction price from the PJM capacity auction at the time of the bidding, we've had to go to this mechanism. The question about what would happen if FERC ultimately ruled in, the favor of anyone who, is challenging these capacity auctions. Again, not just this auction. This is a multi-auction issue. If FERC, though, were to rule in the favor of those challenging the auctions, absolutely, the money would flow back to customers. Rider 8 would probably be a logical choice. Could there be another way to do it? Perhaps. We'd have to see how much the amount was awarded that was back to us, and see what the best way to do that. Again, would we want to necessarily flow it back, depending on the amount, flow it back only through 8 months? That might not make sense. Maybe it would be better to flow it back over a longer time period. Again, just don't know. We'd have to see what the ultimate amount was. But again, this filing was not intended to change anything about the risk. That was already done 5 years ago. Again, it made sense then, and what the commission acknowledged was that, suppliers, when they were bidding, because they didn't know what the capacity auction costs were going to be, the concern was that they would bid in a much larger amount to, kind of hedge themselves. So we went to this mechanism of using a proxy, with there being a true-up ultimately when the capacity auction prices were known.
Okay, Commissioner Linton.
Yeah, thank you, Mr. Chairman. So, and thank you for your presentation. Can you tell us from the use of the PIP now, if the commission doesn't adopt the proposal that you made today to modify the SOS rate, what happens in October?
We would include the difference between the actual costs and the proxy costs in the rider rate calculation per the terms of commission-approved tariff.
Is that something that would have to come back before the commission?
Yes. Well, do those actually normally? No, normally the rider 8 calculations are filed, and they're not, I guess they're an administrative item that the staff just approves.
Staff, could you confirm that for me?
Yeah, those are typically not a buck sheet that comes.
It's not a
before the
buck sheet,
commission.
right? So we wouldn't have it in front of it wouldn't be like on a Wednesday morning administrative procedure.
Exactly.
So basically it would be an automated may not be the most efficient way of saying it, but that's in other words.
That's how rider 8 has
Right.
functioned for 20-some years.
Right. So basically, if the commission doesn't adopt something today along the lines of what you've proposed, then in October, what has happened before, which would be the alternate, I guess more compressed collection of these costs, would begin in October.
Correct.
Okay. regarding, I did have a question regarding your proposal because it is a little different to put these costs through the SOS rate instead, through a rider one. In your filing, you do mention a more assertive communication plan for consumers. Because again, this is not the normal way, to the extent they've been paying attention to capacity costs among the residential market, which probably hasn't been happening as much, although I suspect it'll get a little more attention now with this increase. Does your plan include talking to consumers about some of our demand-side management-related programs?
I think all of our communications that talk about bill increases, rate increases, do also then talk about ways that customers can save on their bills, whether it's, well, by shopping, by using any of the Empower mechanisms. Yeah, those always go hand in hand.
Okay, so we do have a number of the capacity costs flow through a lot of our commission programs, not Empower programs, other initiatives that the commission has endorsed over the years. And so with an increase of this size, that does result in perhaps even a need to take a second look at some of them to see if that capacity cost has shifted something somewhere. And I'm not suggesting it has, I don't know that it has, but this is a big difference than what we've looked at before. Have you talked to some of the People's Council, other advocacy organizations to see if they had any thoughts about some of the educational materials that you plan on using?
No, we have not. But I'll say, since, the issues that arose at the very beginning of the year with, the increased usage that, coupled with increased rates, that drove bills up that people were very concerned about, we have been very, transparent that, not just talking about those, but then talking about the fact that, hey, there are going to be additional increases over the course of the year, including the ones that would be coming in, June from either, the transmission rate increases or, capacity. Didn't get into that level of detail, but we have been, very, like I said, transparent that, we didn't address that. We try to give customers a heads up that, hey, you need to plan ahead because there are other rate increases that are likely over the course of the year.
Okay. All right, so typically customers today are familiar with the SOS rate through talking about the deregulated market, competitive suppliers. So is it your intention then to try and incorporate your material, your education to consumers about this with that type of communication, or is it going to stand alone separately? And I'm just trying to see if I'm trying to make sure that their consumers are not hearing about the SOS rate from two different perspectives from the same source.
I guess I'm not quite sure understanding. I mean, we definitely, when we've talked about the increases to the SOS rate, and then, our communications about the SOS rates, that happen kind of normally, will highlight the change as well.
Okay. All right, that's it for now, Mr. Chairman. I don't want to monopolize. Thank you.
Good morning, Ms. Laura. I understand that you are simply trying to find a way to flatten out the increase. So we'll start now. By the time we get to October, the increases, well, either the customers will be inured to the increases, and then they won't be as significant. But I think we're also talking about increasing those costs based on the capacity auction, and approving the rider today essentially is approving the pass-through, as opposed to addressing it in October. So whatever we do today, it's not just approving this mechanism for softening the blow, but we're also approving the pass-through itself. And so it seems to me that when the issue comes up in October, we'll have already decided this.
Well, I guess, Commissioner, I'd say you approved the pass-through in 2020 when you approved us going from suppliers including capacity costs in their bids to us using a proxy, having the suppliers use the proxy and letting us true that up. That was approved in 2020.
Right. I understand that too, and I also understand that if we were to deny this pass-through, then it's the utility that takes the risk. I mean, the supplier has a windfall, I believe, through this auction. You're simply passing it through. If we were to deny it, the customer won't be impacted, the utility will be impacted. And so I understand that. So it puts us in a terrible box, because we have no ability to say anything about the auction, even though we have concerns about how it was run. I understand the challenges for the utility, because you're simply a pass-through, and not giving you, if you're already paying for this, it's not fair to the utility to not compensate you. But the problem is then that it really is the customer that's taking on all of the risk, and that seems unfair to me too.
I guess, Commissioner, though, I'd say it's not that the commissioner doesn't have any options. The commission has challenged the auction results. The commission can go to PJM and look to changes. I look at this no differently than transmission costs. When PJM, does what it does with transmission, makes the decisions, we have a formula that's approved, we get the rates, what the rates are that are the costs that come through to us, we turn into a retail rate. Can the commission challenge those? Not after the fact. You can challenge, well, I guess you could challenge it by going to FERC, but it's, again, there's I'm drawing a blank now on what the doctrine is, but, when FERC and PJM come up with rates that
It's
are
the filed rate doctrine, right?
It's
No, and I
so
understand.
you have
I've
the option
dealt
to
with
do
this.
it. Yeah.
Right. No, I understand that. The problem is, through all of this, we're being told that we're in a box because we can't do what is fundamentally our responsibility, which is to protect ratepayers. And that's the concern that I have through all of this, is that this auction was run in a very flawed manner, and we're stuck with the results, but it's really ultimately the ratepayer that's stuck. And I'm very concerned about it seems to me that approving the rider is really blessing the results of the auction, and I feel very uncomfortable doing that.
And that's certainly your prerogative. I will say this is, BG is not the first one that has faced, these increased capacity costs. Delmarva faced something similar in prior auctions. The commission certainly expressed concern about those, but to my knowledge, Delmarva was allowed to recover those costs as a pass-through through their normal tariff mechanisms. And so now, again, it's almost like BG is being punished because we tried to come up with a way to lessen the impact on customers. Had we not come up with this idea to spread it over 12 months, come to the commission, put it through, we would have included in our rider rate filing in October, and it would have probably just gone through the normal channels and been approved. And so again, we're being punished for doing something that we thought was the right thing to do for customers, and also we're being treated differently than other utilities who have been allowed to recover the increased capacity costs that came from one of these auctions.
Okay, that's all I have.
Mr. Richard.
Thank you, Ms. Segura. I'm looking at there are two different issues here. We have the integrity of the standard offer service, the whole procurement process, and I agree with you there that we did come up, I think, through the PIP a reforms that made sure that we can always get, and have a solid auction. So that's really not the risk I'm talking about. But I agree with everything you said, and I expect today to support the proposed motion to move forward to make sure we keep the process moving forward. And should there be a decision by FERC in favor of ratepayers, then those refunds could flow back. So that's not what I'm talking about really. But I am concerned about how this all came about in the auction in the first place. And this is where utilities like BGE and your parent company Exelon are not passive standbyers. You are a big part of the governance of PJM. And the concern goes back to when this new paradigm, or however you want to call the design for the auction, was put together. OPSI, the organization of PJM states, had a chance to engage with PJM about it, and we were told, it could probably be about a $200 million impact on cost. So in a $2.5 billion market, we're like, okay, well, these are important reforms, that's good. Then it got filed with FERC, and it was all of a sudden going to be a $4 billion, impact. So, wow, that's kind of an increase just in a matter of months from what you told design to the states was going to be, and we went along with, accepting it and allowing them to go to FERC. Then it became $4 billion. So FERC accepted it. Then suddenly we have the auction. It is a $12 billion increase, and it's 800% increase. And the first, reaction from PJM was simply, well, that's the market. And you're like going, what kind of functioning market has an 800% increase in just one, fell swoop? So I think that's the concern about what's happened here. And they just, for the several months, just went along, nope, we're not going to change a thing, until finally governors, members of Congress, there was an uprising, and then they were like, oh yeah, I guess there were some flaws. We accepted there were some flaws, and we'll start to fix them. So this goes back to now BGE and Constellation. We do have a complaint. I'd like to know, what are you doing as an insider with the governance to try to, one, get, I guess a more pro ratepayer, perspective there, so that they don't just blithely conduct an auction and don't even realize how outrageous it was, and then, what are they doing to try to correct it? I mean, there are complaints right now before FERC. Are you going to, go to your board, the PJM board, and say, hey, maybe we should come up with some remedies to try to recover some of these costs per OPCs and other consumer advocate? Is your company committed? Is Exelon and BGE committed to try to do something to try to fix this flaw?
I'll start by saying I don't do a lot of PJM or FERC work. I focus more.
Well, you're the person here right now from Exelon
I
BGE,
understand
so
that,
that's
but-
not an acceptable answer. What?
I can say that Exelon and BGE are doing what they think is right to get the markets right. What that ultimately
So 800% increase in costs in one auction
I-
is getting the market. So you agree with the PJM board, is what you're
I
saying?
can't
That's
say
the,
that
that's the
that's-
stance of Exelon right
No,
now.
absolutely, I'm not saying that. I apologize. I was not expecting this discussion. Otherwise, I would have brought.
Well, you came here today for the pass-through. This was the first really opportunity
we
to
came
talk
here
about the
to
auction
say
results.
Where the pass-through was being done. The pass-through was approved 5 years ago. I came here
No,
to change the
we're,
manner.
okay, you're mixing, don't, I understand, I support the PIP process, okay?
Yes.
I'm fine with that. I want to know what BGE and Exelon are doing
We are
with
engaged
the
state-
PJM board to try to see what we can do to fix it. I mean, you've got OPC standing right behind you. They are actively trying to work on behalf of ratepayers. I
And
mean,
I
will you join them also as a member of the PJM, sectors, there is 5 sectors, in trying to do something to help remedy the situation for
I
ratepayers?
can say that we will absolutely 100% continue as we have all along. I will not say that we did not, attempt to come up with the right solution at any time. Did we always get what we wanted or what we thought was the right solution? I don't know. But, again, while OPC is going to focus on customers, we also have to make sure that, if you have a remedy that is so one-sided that it's going to wholeheartedly protect customers, you may kill the market because no supplier will want to participate. So there is a balancing that has to happen. You can't.
Again, I apologize. I don't mean to be badgering you here, but what's happened by, what PGM has done is so outrageous. And at this point, they didn't get it at the beginning. They finally are getting it for the next auction. It's just, what are they going to do to remedy what everyone accepts was a flaw, a huge flaw, and yet, and we now have an unjust and unreasonable rate that we're staring at. Yet no one seems to be doing anything about it that can, on the side that made the mistake. It's all being borne by that. So again,
I'm sure we are absolutely working very diligently to come up with a better solution.
Okay. Well, I hope you take back to excellent. I hope, again,
I
we have some
absolutely will,
results.
100 will.
Okay. I hope it bears some results, because you're a transmission owner, and you're as a EDC.
And we are only one entity in a very
You
large
are a very powerful
and
entity
there are
in
many
your
other
sectors. So,
powerful entities. that have
we
different-
recognize you as a very powerful member of
Yes.
two sectors. So thank you. Thank you, Mr. Chairman.
Commissioner Barbe.
I'm good.
Okay, so let me understand. The charm of this proposal is that we take this significant amount of increase and we spread it over a longer time period, so it has less of a consumer impact. The risk is that if we actually succeed at FERC and this thing gets overturned, people will have spent money that maybe they wouldn't have had to have spent, because if FERC takes any action, their refunds, it's going to be prospective. They're not going to give money back, correct? Right?
So I don't believe I introduced myself. Good morning, Mr. Chair and Commissioners. Drew McAuliffe on behalf of staff. So yes, so the charm, as you phrased it, is yes, it's spread over 12 months, and it is more transparent. So as we noted, the Rider 8, it is not a buck sheet. It's usually just automatically approved, and that's it's kind of a hidden rider. Customers don't really see it. They're not well aware of it. So they'd see a big increase. So it'd probably be around $20 per month. That would kind of be invisible to the customer. Whereas we agree with BG, this is more transparent. And yes, obviously any refund would have to be, would probably wouldn't occur. I don't know the FERC's timeline, but 6 months from now, a year from now. So customers would, have to pay up front and then be credited later. I would note, as Ms. Sikora alluded to, staff would have some concerns about, just say the commission didn't accept this Rider 1 or the Rider 8 increase, suppliers may get a little nervous, and that could lead to higher prices for ratepayers in the future, because they may not participate in future SOS bids, or they may include a higher risk premium because they'd be concerned they're not going to get their full costs as well. So that is a concern of staff as well that we think it's important to note.
But isn't there another danger, though, in adopting this today? Because one of the problems we had earlier was, because of the normal wintertime temperatures, usage went up, and so therefore people used more electricity and energy, and therefore wound up paying a lot more. And when that increased usage was also timed with increased prices, it was like a double whammy. And so don't we run the same risk if we do it today, that we're right before summer, and so we get the situation of high usage and, could theoretically even start in May, as opposed to actually waiting till October and seeing what happens then?
That is an option. I mean, obviously with the weather is a huge determinant of usage, and it's hard to say. Obviously in October you'd expect less usage than in July, but for example, if you have electric heating, typically your usage is actually higher in the winter than the summertime. So you could run that risk as well if it's a cold winter again, and we're only collecting this over 8 months. It could hurt those customers as well. So it's kind of 6 and 1/2 dozen the other. It could hurt customers either way, unfortunately.
Okay. So let me, OPC, since you haven't had a chance yet, go ahead. So.
Thank you, Your Honor. Michael Sammartino on behalf of the Office of People's Counsel. I should say that I was not prepared to come to the dais today, and I can't really answer any specific questions about the company's filing or staff's comments, but I just want to note the timeline for the complaint that we filed with the FERC. And we filed our complaint on April 14th, and we asked for expedited treatment and for the commission to grant that complaint by May 31st, 2025. We also asked that PJM respond within 15 days. So to the extent the commission is considering deferring judgment on the matter currently being discussed, we should know within the coming weeks what direction the FERC might take and what posture PJM is taking with respect to our complaint. And I also would like to note that even assuming that FERC does grant our complaint as we request by May 31st, refunds would the process for refunds might take longer, and so the relief that if our requested relief is granted, it's not going to be instantaneous, reflected in customer bills on June 1st. So that's I can answer very limited questions, but I just wanted to make that note for your decision making today.
All right, Commissioner Richard.
Yeah, thank you. I appreciate your being here today. I guess it's my intention today to support the proposed, the recommended, I should say, motion, and that is to support the pass-through for the purpose of maintaining the credibility of the SOS auction and for the PIP. It is recommendation of the PIP. Is that a position that OPC supports?
Ryan Chu on behalf of the Office of People's Counsel. Yeah, I think we're in terms of the instant filing, in terms of do we put it through the 12 months starting in June or 8 months starting in October. I think we agree with staff's assessment of like a half dozen of one, 6 on the other. It's hard to say. You could be, the increase, you could be putting it in the summertime, which could be bad. Alternately, you have an even higher increase starting in October, and if it's an ever cold winter, that would also be bad. It's kind of just bad all the way around. So, I think either option is plausible, but yeah.
Okay, so you're good supporting staff today,
Yeah.
which I think is the right thing to do. Again, to support the SOS auction process.
I think that's fine, and yes, I think there. While we haven't necessarily fully analyzed, I think there could be concerns if we don't. Yeah, if we don't approve any of the capacity costs going through, that could be some sort of ramifications on the SOS suppliers and what would happen in the future. That could be.
Okay. Well, thank you. It doesn't make me any less angry at PJM for running such a flawed and onerous process. But anyway, thank you.
Thank you.
Commissioner Barbat.
No, I'm fine. Thank you.
Commissioner Sussman.
So I guess from OPC's perspective, is there any recourse that we have to address a flawed capacity auction? I mean, that is my concern. I mean, I understand from BG's perspective, this is simply a pass-through, not allowing for recovery for them is going to impact that company. But I mean, what do we have any recourse?
That's a good question, Your Honor.
No, I appreciate it's a good question. I'd like a good answer. Do you have a good answer?
I wish I did. I think, specific to the issue of the 2025-2026 DRA, that's, we have an ongoing a complaint at FERC, and I think engagement in that proceeding might be helpful. But, I know there's, some question about, the extent to which state commissions can more actively engage with PJM and their kind of decision-making process. And so, yeah, I wish there were better, I could give a better answer, but that's, I think in the near term, engagement in the docket regarding our complaint.
Okay, thank you.
Commissioner Litton? Any questions? Okay. All right, so I think what we're going to do is actually take this under advisement. I've sort of heard enough to raise some questions that I think we need to kind of go back and figure out, because there seem to be a lot of competing factors in this situation between, you know, the spreading it out over a longer time period or coming, you know, dealing with summertime versus wintertime. And then the whole situation about what may happen at FERC, and we actually are participants in some of the FERC proceedings. So I guess I just want to take a little time with this. So we're going to take this under advisement and issue some indication as to whether or not we can consider accepting a tariff now or accepting a tariff at some point down the road. So, all right.
Thank you, Commissioners.
Mr. Chair, item number 5 also consists of tariff revisions from Baltimore Gas and Electric Company.
Morning, Mr. Chair and members of the Commission. Oladipo Fadei on behalf of staff. On March 7th, 2025, Baltimore Gas and Electric Company filed Supplement 731 to its electric tariff in compliance with Commission Order 91297 to modify the company's residential electric vehicle smart charge management program. Whereas enrollment in the program currently requires customers to register a supported EV, the proposal would allow customers to enroll using an approved Level 2 charger. The proposal would also alter incentive requirements to begin offering reduced managed charging credits to customers using Level 1 chargers for eligible EVs. Staff recommends that the Commission accept BGE's proposed supplement with an effective date of April 23rd, 2025. I'm available for questions.
Any questions? You okay? Okay.
Good morning, Chair. Joel Michelle on behalf of BGE. We thank staff for its analysis and what I hope is a less contentious item, and we are available for questions.
Okay. Just so anybody, any questions?
Mr. Chair, I feel like this is a challenge.
Yeah, that's right. Well,
I'm assuming you would prefer not to have any questions.
That's correct.
No, we're so. Just one thing, though. So this is the program that was initially started because of the DOE grant.
Yes.
Okay, and you're finished with the DOE portion of this thing.
That's correct.
Okay. All right. All right. So with that, I move we accept supplement 731 to the Maryland E6 for rider 33, electric vehicle charging rider, for filing with an effective date of April 16th, 2025. Commissioner Litton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 6 is Washington Gas Light Company's 2024 annual stride report.
Good morning, Chair Hoover and members of the Commission. Staff present, Tanika Alexander of the Accounting Investigation Division, Evan Thomas of the Telecommunication, Gas and Water Division, and myself, Negotiators Faye, on behalf of the Engineering Division. Strategic Infrastructure Development and Enhancement, or STRIDE, is a program authorized under Public Utility Section 4-210 that allows the accelerated replacement of certain gas plant infrastructure in a 5-year plan with cost partially recovered using a surcharge. Each year, the company is to make a reconciliation filing regarding actual cost and collections under surcharge. On March 17, 2025, Washington Gas submitted its calendar year 2024 annual STRIDE 3 report and reconciliation filing. That is the first year of STRIDE 3 in case number 9708. The company's filing provided an update on the company's progress regarding the implementation of the overall STRIDE program through December 31st, 2024. As of December 31st, 2024, the company remediated or replaced 1,477 services of the planned 1,297, installed a total of 3.8 miles of mains, versus 3.7 miles planned for replacement and retired 6.6 miles of planned 6.5 miles of mains from the system. WGL spent approximately a total of 53.1 million for all calendar year 2024 STRIDE projects. That's about 102% of the company's estimated total cost of 52.3 million for all programs. The staff have reviewed the revenue requirement calculation in WGL's calendar year 2024 STRIDE annual report, which includes the calendar year 2024 reconciliation STRIDE factors, and believes the calculations are accurate and that the total STRIDE investment expenditures are within the Commission's approved budget. The calendar year 2024 annual report filed on March 17, 2025 indicates that Washington Gas over-collected 328,436, which includes 29,985 in interest. This reflects a decrease of 10,865 or 3% from the calendar year 2023 over collection amount of 339,301. The reconciliation factors are netted with the current STRIDE surcharge and then compared to the applicable surcharge caps. The staff recalculated the total cost of 9,301,785 less interest of 29,985 equals the actual STRIDE revenue requirement for 2024 of 9,271,800. The calendar year 2024 reconciliation STRIDE factor for the residential class is calculated to be credited of 9 cents, inclusive interest. Staff recommend that the Commission note the company's calendar year 2024 annual STRIDE report filing, which includes the company 2025 surcharge with the calendar year 2024 STRIDE reconciliation factors. The staff are available to answer any questions you may have, and thank you.
Okay, any questions for staff? Mr. Sussman.
Morning, Mr. Tesfaye.
Morning.
So you're not making a prudence determination in your review of the spends. You're just looking to see what they spent and whether they calculated the spend correctly.
That's correct.
Okay. And so when will you be making a prudence determination?
I think it's during the rate case.
Okay. So, and that's going to be, you don't, whenever they file it?
Yes.
Okay.
Good morning. Evan Thomas on behalf of staff. They have to file a rate case before the end of the STRIDE plan. So 2024 was the first year of their STRIDE 3, and so it'll be 5 years after the start of 2024. Sometime within that span, they have to file a rate case.
Okay. Maybe Mr. Nichols will be able to let us know. Okay. Thank you. That's all I have.
Anybody else? Commissioner Richard.
Yeah, just one question. So overall, looking at this, your report, it appears to be, fairly in order. A little bit of overage here, about 102%. But as far as that compared to what they said they were going to get done in this last year, are you satisfied? Is staff satisfied, or do you have any concerns right now about the direction how this is playing out this third cycle?
Yeah, thank you for that question. Generally, we will be glad if we don't see any overspend in the amount of budget which is spent through STRIDE activity. But we hope yes, the company is making some kind of progress on this regard, and we don't have any issues this time.
Okay, good. So it's not just the overspend, but making sure they're actually getting
Right.
done what they said they were going to do with the $53 million.
That's correct. Beyond that, we would like to see more the companies when they design their project list, make sure they do make sure they get the right project in the list so that it doesn't happen, remove some of the project outside of the project list during the stride calendar year.
Okay, good. So nothing to highlight that you have concerns with at this time for
That's
the commission.
correct.
All right, terrific. Thank you so much. Thank you,
Thank
Mr.
you.
Chairman.
Okay, good deal.
Good afternoon, Mr. Chair and Commissioners. First, let me say to Commissioner Litton, on behalf of Washington Gas, welcome back. We're happy to have you and your experience on the bench. We're happy to report, as Mr. Tesfaye did, that the company was well within the range of its estimates for 2024. We appreciate staff's review. With respect to your question, Commissioner Suchman, I'm sorry I can't tell you when we're going to be filing our next rate case because I don't know. Obviously, there's a lot happening in the world right now in the economy, and a lot remains to be seen. But it is in our interest to let staff and the commission know ahead of time, not to surprise all parties when the filing of a rate case.
So, any questions for the company? Seeing none? Okay, so go ahead and.
Thank you, Mr. Chair and Commissioners. Ryan Shu on behalf of OPC. We don't necessarily have a problem with this filing. I just wanted to comment on Commissioner Richards' question about the sort of the progress and what the company has done. I just wanted to note that as OPC originally raised back when this Stride 3 plan was being approved by the Commission, sort of the pattern is that the company comes in with a proposed plan. I believe the proposal was somewhere around 6 to 8 miles of main to be done per year, and the plan gets the plan was reduced, I believe, by POJ by about a third in terms of the budget, and then WGL comes in and files its sort of its project plan, which and then they base the sort of percentages you see in this filing. We completed 100% of this based on that proposed yearly project plan, which had 3 miles of main being done with reduced budget. I think it's not necessarily there's I think we have some trepidation about whether or not the commission is essentially getting what it thought it was getting when it originally approved the Stride plan. If we're getting 3 miles of main done instead of 6, admittedly with considerations of reduced budget, but just wanted to note that we do have some trepidation in terms of Commissioner Richards' question regarding what the company has done. Now they completed within more or less within budget and completed what they said they would do in their project list, but the sort of shrinking of the project lists each year versus what was originally planned in the Stride plan when it's approved, I think is something that we have slight concern about, but not necessarily to the point of requesting anything at this time or in this filing. Just wanted to note that. Thank you.
Okay, so this is a question for actually both, well, I guess all three. So the General Assembly this past session enacted legislation and includes some changes to the Stride law. Assuming that gets signed, I don't know what its effective date is, but it's probably either July 1 or October 1. How is that going to be implemented through the Stride plans that we got in front of us?
Chair, Commissioners, Michael Dean on behalf of staff. Staff is currently reviewing the changes that are being made. Obviously, some of them can't change retroactively what's been ordered and approved as far as the overall project list. However, there appears to be some parts of the legislation that would require some analysis to be done as part of the recovery, which you'll be seeing in the future in their filings, I believe.
WGL, what's your thoughts?
It's no surprise, Mr. Chair, we too are still working through the Senate Bill 937, but I certainly can represent an agreement with Mr. Dean. The statute does not explicitly say it was intended to apply retroactively.
No, I understand that part, but I'm just wondering if you're going to have to make a revised filing somewhere down the road after it takes effect to implement whatever because the goal of the legislation was to try and narrow the focus of what qualifies under stride. So
I think all I can say right now, Mr. Chair, at this point, is that the statute or the bill that will likely become a statute does not have an explicit requirement to file new stride plans, like, if you recall, the change the Empower statute did last year.
Okay.
Thank you, Mr. Chair. OPC's opinion is that, as regards, 2024, what already happened in 2024 and things that are, being constructed, through, until the legislation gets enacted, this year, I think, probably doesn't affect it. However, our belief is that, as considering this is a 5-year stride plan and we're going forward, we got another 3 years going forward. Our thought is that the commission can and should take a look at those future plans, considering that they're basically project lists that are being done each year, and commission should be evaluating evaluating those future stride plans in light of the changes likely forthcoming, assuming the bill gets signed.
Okay. All right. With that, I move that we note the company's 2024 annual stride report filing, which includes the company's 2025 surcharges with a 2024 stride reconciliation factors. Commissioner Linton.
Aye.
Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. And with that, we're adjourned. Now, for those who are here for the status conference in the BG&E multi-year plan, we're going to take a 15-minute break, and then we'll come back and start that up. So. Okay, so we're on the record for case number 9645. This is a status conference in BG&E's pilot multi-year rate case focusing on the commission's staff's engineering division's investigation into alleged deficiencies regarding BG&E's system supply inspections. The engineering division filed its report on April 11th. BG&E filed a response to staff's report on April 17th. We noticed for hearing on this conference on April 18th, and then received comments from OPC. So let me take appearances to start.
Good morning, Dawn White, Vice President of Gas for BGE.
Good morning, Chair Hoover, members of the Commission. David Ralph on behalf of BGE.
Good morning, Your Honor. Michael Sammartino on behalf of the Office of People's Counsel, and with me as well is Mark C. Shippist.
Good morning, Chair, Commissioners. Michael Dean on behalf of staff. I'd also like to enter the appearance of Lloyd Spivak, and I have John Clementson here with me to answer any questions you may have.
Okay, so what we want to try to do today is get comments from the parties regarding what procedural steps the commission should take regarding the staff's engineering division's investigative report. And so I'm going to start with staff. I'm going to go then to BG&E, then to the Office of People's Counsel, back to BG&E, and end with staff. So Mr. Dean, if you would like to start, go right ahead.
Hi, John Clementson on behalf of the Engineering Division. I'm the Deputy Chief Engineer with the division. Before we kind of get started on the direction of future proceedings, if there are any, I do have one of the recommendations, and have a change to it. So bring that up first real quick. Pretty much the last page is the report. The current recommendation as it is written is immediate issuance of commission order directing BG&E to produce a list of all projects inspected by the discredited employee. Upon review, that was not quite what I intended there. I apologize for writing late at night. The revised recommendation should be immediate issuance of a commission order directing BG&E to produce a list of all projects that were assigned to but not inspected by the discredited employee that were inspected by other inspectors from the Corrosion Leak Proactive Service Renewal Program for 2022 until his termination.
Okay, just so we're all on the same page, you're talking about page 16 of the staff's report, correct?
Yes, the first bullet.
Right, so you want to replace the current first bullet in the report with this new bullet based on the filing you made today.
Yes, and I have copies for anybody who would like a copy of that right now.
Alrighty.
And if I could, I just want to be clear for the record that what was previously marked as the first bullet that was referred to by Mr. Clementson had already been provided by the company, not as stated in the report.
Sure. Okay. Good enough. Okay, Mr. Dean, or do anything else from Mr. Clementson, or back to Mr. Dean? So.
I have nothing else at this time.
All right.
Thank you, Your Honor. Staff provided its recommendations, and since the current proceeding is actually part of a rate case, and this the scope of this investigation has somewhat a different topic and statutory compliance than the rate case. If the commission desires to further investigate this matter, staff would recommend that the commission consider establishing a new, docketing a new proceeding to do this investigation and allowing parties to intervene and be heard in this matter.
Okay, any questions for staff counsel on that? All right.
Thank you, Chair Hoover. BG's position would be similar, that the matters that have been raised, should the commission deem it appropriate to do further proceedings, that it should be docketed as a separate matter, not part of the rate case. So that's our position in terms of, the procedural. But I do want to have an opportunity to comment on what we provided in terms of our response to the Commission Engineering Division's report.
Well, do we need to hear that today if we're going to docket another proceeding? Because I actually want to avoid getting into the substance of the staff's report. And one of the reasons is because so much of the information in there is confidential, and I'm concerned that we're going to be running in and out of confidential sessions if we start down that path. So, I mean, if we decide to have a separate proceeding, I would think at that point you would have every opportunity to respond to what's in the report, what you agree with and don't agree with. So.
Sure, I
Okay.
think that's a fair position.
Okay. Well, let me turn to OPC.
Thank you, Your Honor. We agree that this would be best addressed in a separate docketed proceeding. I think one question we have is, one of staff's recommendations is to conduct an audit, and the question is whether that audit should proceed before before discovery or if an evidentiary proceeding is scheduled, or if it should proceed concurrent to discovery for a subsequent docketed proceeding.
Okay, so let me first turn to staff. Why don't you describe what you envision happening with this audit, and then I'll get reactions from the other two.
Thank you, Your Honor. Since he was intimately involved with the scope of the investigation, I'll let Mr. Clemenson address that.
What we envisioned was possibly a third-party audit, to bring in a fresh set of eyes, an independent audit to look at this, to see if it was just a localized event with this one particular program that the company runs, or does it run across other various programs or units within the company, to see if it was a localized or I can never say the word, systemic problem.
Okay. Any questions?
Yeah, thank you, Chair Hoover. I guess my concern is whether, of course, any further proceedings are even necessary, and whether certainly the resources for an audit are necessary given our position regarding the duties of this individual and its impact on our system safety, which of course has been our position, that the former employee in question's work was not system safety work, was contract compliance auditing that's done on a sample of contractor work. So the question for me is really, is it even appropriate to have this resources spent when there hasn't been anything that demonstrates that there has actually been an impact on the safety of our system. And if I could just briefly, you know, we have had a long partnership with the Public Service Engineering Division, and that's an important partnership for what we do for customers. And to make sure that we're in compliance with regulatory standards. But clearly, there was some misalignment in terms of this report. And to the extent that there were miscommunications or we weren't clear enough on our part, we certainly take responsibility for that. But I want to be clear. It is our position that safety is a top priority for BGE. We take safety very seriously, and we continue to be one of the safest utilities in the country. And that we employ a multi-layered mechanism for ensuring safety, and that this work done by this former employee has no bearing on that. It's not related to that. It's related to things like, you know, contract, like I said, contract compliance, such
Right.
as.
I understand. So I think we got your point about the audit. So let me hear from OPC.
Yeah, just to you know, at the very least, the BGE's response to the engineering division's report and the findings of the report itself indicate that there's clear material issues of fact that need to be resolved, and I think that would be appropriately resolved through an evidentiary proceeding.
Well, I understand. I guess
Yeah.
my focus is this question about this outside audit and the necessity, which you've sort of raised, and they've sort of explained what they think it would do, and you've heard BG&E's reason why it's not necessary. So what's your view on it?
Well, counsel for BGE, I think, is looking at the report in a it's construing it, the findings more narrowly than we see, because the issues with the employer, with the former employee, there's ramifications beyond just the safety of BGE's system. There's the, you know, matters regarding the, you know, whether the employee was appropriately was charging the company for work that he actually performed. Like there's issues like with respect to BG's oversight of its employees that warrant further investigation.
Any questions for anybody, or? Okay.
May I respond briefly?
Sure.
Mr. Chair. So first of all, as you know, we have excluded the employee's salary just out of the abundance of caution from any recovery that we're seeking. You know, in terms of oversight of this employee, the first of all, the concern of the report, the reason why I think we're all here is because the report expressed concern about the safety of BGE's system. That's the reason that the report was done, and that's the reason why I think we're here. What I'm saying is there is the work that this employee was doing did not have any bearing on system safety. It was contract compliance, such as making sure that there are flaggers on site, making sure that that crews are operating within the confines of their permit, making sure that the contractors are there when they're supposed to be there, making sure that contractors also have on the proper protective gear so that they're not injured doing the work. There's, you know, OPC suggesting that this should be some broader investigation into HR issues, how, you know, BGE monitors its employees, is not the focus of the engineering report. And I think, you know, we should be careful not to broaden this into something that would be unwieldy.
Fair enough.
If I may respond, Your Honor.
Very briefly.
So there's, I guess, you know, in looking at, I'm trying not to go into materials that the company is marked confidential. Just in looking at the job description, which I'm not going to detail, there's additional responsibilities that this employee has, or this former employee had, that don't relate to the field audits that BGE has discussed in their response. And those responsibilities pertain to costs that customers ultimately are paying for. And to the extent that there's an employee in the company that is not showing up for work when they should be, using company equipment for non-work related matters, that there's, setting aside the safety issues, which are, very concerning, there's further concerns with whether customers are getting the quality of work that they pay for.
Okay, so let me end with staff. Any last words on the independent audit issue?
Not at this time.
Mr. Dean, anything?
Well, our recommendation on the audit, we were concerned of the company's adherence to its inspection procedures and protocols. And given that we have a person that was absent and it wasn't discovered until later, raised some concerns with us. And an audit would look at the company's procedures for how it supervises its employees, and especially in this area of having contractors do the safety related work, how they are adhering to all the requirements under their contract for doing this work.
Okay, all right. Any questions? All right. Oh, okay, go ahead. Hmm? No. Oh, yeah, so.
Just one final point. I promise I'll be quiet.
right.
I'll be quiet after that. I just want to just remind the commission that we have 3,200 employees. We found out about this on our own. This was part of our internal investigation on our own, and that we continue to investigate. We continue to monitor all our employees. We have tracking mechanisms. These are things we have in place now, today. We have also enhanced the processes that we have to oversight. So again, I think these are normal HR. Unfortunately, when you have humans, these are HR issues that occur. And we have addressed it. This employee no longer works with us. So again, I hear the concerns raised, but in an organization of our size, and any organization, including OPC or any other organization, there are always, unfortunately, humans that deviate from the standard that we expect of them. But we investigated it, we have caught the issue, and we have addressed it. Thank you.
Okay, so we're going to issue an order, either docketing a new proceeding or just continue it as part of this case, and that decision will include a decision regarding whether or not we want an independent audit prior to that proceeding.